Hi, everyone, and welcome to episode 15th of Study With Me. European Union law, this podcast helps you get ready for your university exams and gain a deeper understanding of the subject. We know that trying to study EU law often feels like trying to assemble this massive, really complex piece of legal architecture without the instructions. You've got treaties, directives, regulations, principles, all sort of stacked up. How do you know which one wins if they clash? Okay, let's unpack this. Our mission today is pretty simple. We are tackling the essential hierarchy of sources. ERIFREM. Think of this as your exam cheat sheet for understanding the EU's foundational legal system. We need a really clear, structured map. It needs to tell us exactly what sits at the top, why it gets called a constitutional charter, and crucially, why that matters for you.
That really is the key distinction, isn't it? When you walk into your exam, you absolutely need to be able to spot the um, the legal value of every single instrument.
Yeah.
From the big foundational treaties right down to, say, simple policy guidelines. Understanding this hierarchy, well, it means understanding legality, legitimacy, and enforceability across the whole EU system.
Okay, let's kick things off right at the very top then. Level one, the undisputed foundation, primary law. If the EU legal order is like a building, this is the concrete foundation, the structural steel. Yeah.
Exactly. Primary law is the constitutional bedrock. And this includes the core treaties, the Treaty on the European Union, the TEU, and the Treaty on the Functioning of the European Union, the TFEU. And remember, Article 1 of the TEU, it actually confirms they have the very same legal value. So it's like a single unified foundation. And we also have to include the Charter of Fundamental Rights of the EU, the CFREU. That gained the same legal status as the treaties with the Lisbon Treaty. Oh, and don't forget the accession treaties. Those are the ones that legally bring new member states into the Union's framework.
Right. And the role of these treaties, it's not just procedural, is it? It's kind of revolutionary. They didn't just set up institutions. They really fundamentally changed the legal relationship between individuals, states, and the union itself.
They absolutely did. I mean, they provide the fundamental legal regime. They give all the necessary powers, the competences to the institutions for everything that comes after.
Uh-huh.
And crucially, they don't just put obligations on governments. They actually grant rights and impose obligations directly on individuals.
Yeah, and we can't really talk about primary law and individuals without mentioning Von Gent and Loos, can we? That case.
Wow.
It wasn't just a court decision. It felt more like a constitutional revolution.
It truly was a landmark. That decision established the doctrine of direct effect. It confirmed that EU law creates this new legal order, a new system where states have limited their sovereign rights. And importantly, the subjects of this new order aren't just the member states, but also their citizens, their nationals. That decision is basically why you, as an individual, can potentially stand up in your national court and use an EU treaty provision against your own government.
Okay, now here's where it gets really interesting. The ECJ itself, the Court of Justice, defined the treaties as the constitutional charter of a community based on the rule of law. That famous line, it came from the Les Verts case way back in '86. But if it's a constitutional charter, which sounds pretty permanent, pretty solid, how does that description fit with the fact that member states can and do amend the treaties quite a lot?
That's a fascinating point because that designation, it really highlights this sort of tension right at the heart of the EU. Politically speaking, maybe it's not a fixed constitution like some national ones. Changing it needs constant agreement between governments. Legally, though, the court treats it very much like a constitution. And what that means in practice is the court often uses systematic and teleological interpretation. So they don't just look at the literal words on the page. They look at the context, the overall purpose, the objectives of the whole union, making sure provisions are interpreted in a way that helps the union achieve its goals. And just a quick note here on the sort of fine print of primary law. You've got the protocols. They're attached to the treaties. Think of Protocol number 4 on the Statute of the European Central Bank, for instance. These have the same primary legal value as the treaties themselves. That's Article 51 TEU. They fill in details, regulate specific things. Declarations, though, are different. They aren't legally binding. But they can be useful tools for interpretation, showing the political thinking or the context when the treaties were being formed.
Okay, that makes sense. Now, what about those principles? The ones that aren't maybe written down in one specific treaty article, but the courts seem to rely on them constantly. We're moving on to the general principles of EU law, which you said also share that primary law status.
Yeah, they sit right up there with the treaties. These principles are, well, they're essentially the court's toolkit for ensuring justice and coherence in the system. They do 3 really critical things. First, they fill legal gaps. This was especially important when the EEC, the early community, was brand new and didn't have rules for everything. Second, they act as parameters for interpreting all other EU law, whether it's the treaties or secondary legislation later on. And third, they function as parameters for legitimacy. They make sure that everything the EU does, sometimes even looking at the treaties themselves, lines up with fundamental values like human rights.
And just like the treaties, these principles are binding everywhere, on the institutions, the member states, even individuals.
Yes, absolutely. The Mangold case really cemented that. It showed the principle of non-discrimination, for example, could be enforced even against a private company, an employer.
Wow. Okay. So they're powerful.
They are. You could say the general principles are the true guardians of the EU legal order.
Right. So for exam purposes, we absolutely must nail down maybe two key principles that really show the power and the reach of EU law. Let's focus on Effet, Utile, and loyal cooperation. Can you tell us about Effet Utile first, the principle of effectiveness? Why is that so vital?
Effet Utile is, well, it's about making EU law work in practice. It basically stops national courts or authorities from doing things that undermine EU law. It forces them, compels them, to interpret any EU provision in the way that best allows it to achieve its objective. So imagine your national law gives two possible ways to read an EU directive. If Utile says you must pick the reading that gives the EU rule its most useful effect. The Adidas case is often cited here, related to intellectual property, showing how this principle works.
Okay, so it ensures the law actually does what it's supposed to do on the ground.
Exactly. It guarantees the practical effectiveness of EU rules. And, really importantly, it ensures individuals can actually get a remedy, get redress, if their EU rights are violated. The Brasserie du Preur case confirmed this link to compensation. So, Effet Utile ensures EU law has real teeth, not just words on paper.
Got it. And then there's loyal cooperation. It sounds quite polite, like a gentle request.
Yes, the name sounds mild, but legally. It's a fundamental mandatory obligation for member states. A legal hammer, as you put it. They must actively carry out the treaties, help the union achieve its tasks, and crucially, they must avoid doing anything that can jeopardize the union's objectives. And what's really key here is its scope. It works vertically between the member states and the EU institutions, but also horizontally. So between the member states themselves and even between the different EU institutions, it kind of holds the whole structure together through mutual obligation.
Right, that makes sense. It's the glue. Okay, so that brings us down a level in the hierarchy. We've established primary law. What comes next? And how do we clearly separate it from what we've just discussed?
Okay, so we transition down to secondary law. Its place in the hierarchy is really clear. It sits below primary law, always. These are the laws, the acts adopted by the EU institutions, the Commission, the Council, the Parliament. But, and this is vital, their entire legal force comes from the treaties. If a piece of secondary law clashes with a treaty provision or a general principle, then that secondary law is invalid. Primary law always wins.
And within secondary law itself, we have that really crucial split you mentioned earlier, the difference between binding and non-binding instruments. We definitely need to be crystal clear, especially for exams, on the three main binding acts. These are the ones we probably encounter most often.
Yes, the three binding acts are distinct in how they work, how they apply. First, you have regulations. Think of these as the heavy artillery of EU law. They are binding in their entirety, every single part, and they are directly applicable in all member states. They don't need any national laws to bring them into effect. They just apply immediately.
Instant unified law across the EU.
Then you have directives. These are more like strategic planners. They are binding, yes, but only as to the result that needs to be achieved. They set a goal. How member states get to that goal, that's generally left up to them. They choose the form and methods, usually by passing national laws within a specific time frame. So directives offer flexibility on the how, but what the end result is mandatory.
Right, so they harmonize laws by setting common objectives.
Precisely. And third, you have decisions. These are like targeted strikes. They're binding in their entirety, just like regulations, but usually only on those they're addressed to. That could be a specific member state or maybe one or two companies involved in, say, a competition case or even an EU institution itself. Very specific application.
Okay, let me quickly recap that. Regulations, instant, directly applicable EU-wide law. Directives, binding on the result, need national action. Decisions, binding fully, but only on the named addressees. And below those binding acts, but still technically within secondary law, we have the non-binding stuff.
That's right. The main ones are recommendations and opinions. They're important politically. They show the institution's thinking. But they don't have binding legal force. You can't usually take someone to court for ignoring a recommendation. They're more like guidance.
Okay, guidance, not orders. Got it. Now, before we hit the very bottom level, you mentioned international law. Where does that fit into this stack?
Ah, yes, international law. This includes things like general international norms, basic principles like pacta sunt servanda, meaning agreements must be kept. And, very importantly, all the international agreements the EU signs with other countries or international organizations. Think trade deals, environmental agreements, that sort of thing.
So where do they sit in our hierarchy? Above or below secondary law?
They sit quite high up, actually. They are definitely above secondary law. This means that an EU regulation or directive must comply with the international agreements the EU has entered into. But, and this is a crucial but, they are strictly below primary law. The treaties, the charter, the general principles, they remain the ultimate source of legality within the EU legal order. An international agreement can't override the treaties.
Okay, that's clear. Treaties on top, then international agreements, then secondary law. Right. So finally, let's look at the lowest rung of the ladder. This is often called soft law. It's got the least legal bite, but maybe it's used a lot for political coordination.
That's a good way to put it. Soft law instruments are, by definition, without binding force. They are not law in the sense that a regulation is. They're not typically justiciable. You can't enforce them directly in court in the same way. So what are we talking about here? Examples would be things like communications from the Commission, various guidelines, action plans. Their main purpose is often policy coordination. They signal the Commission's or another institution's policy intentions. They provide guidance to member states or industries, and they can encourage member states to align their national laws or policies, even without any legal compulsion. They show you the direction the EU is thinking of heading, politically.
Perfect. So we have the complete stack now, the whole hierarchy. Let's just quickly visualize that recap for everyone listening, maybe going from the very top down. Level 1, the absolute constitutional core. That's primary law. Treaties, TEU, TFEU, the Charter of Fundamental Rights, and the general principles of EU law.
The foundation.
Level 2, the EU's external commitments. That's international law specifically. The agreements the EU concludes with third parties.
Sitting just below the treaties.
Level 3, the everyday workhorses, the institutional acts. That's secondary law. And remember the split here. Binding acts like regulations, directives, decisions.
And the non-binding ones like recommendations and opinions.
And finally, level 4. Policy intent and coordination. That's soft law, things like guidelines, communications, action plans. No binding force.
That maps it out nicely. And, you know, if we just connect this back to the bigger picture for a second, that term constitutional charter we discussed earlier, it makes the structure sound very fixed, very static. But it's important to remember, the treaties themselves are deliberately designed to be amendable. The mechanisms for changing even this top-level law are part of primary law itself, built right in. It ensures the structure can adapt over time.
Right, that's where the political reality really meets the legal structure, isn't it? Specifically in Article 48 of the TEU, which lays out the different ways the treaties can be revised. You've got the main one, the heavy lifting ordinary revision procedure, that usually involves calling a convention, then an intergovernmental conference. And crucially, it needs ratification by all member states according to their own constitutional rules. That takes time and political will.
It does. But there's also flexibility built in through the simplified revision procedures. The first one applies only to changes within Part 3 of the TFEU, the internal policy section, and it can't be used to increase the EU's powers. The second simplified procedure, and this one is politically very interesting, is the Passerelle Clause, also known as the Bridging Clause.
The Passerelle. This is the one that allows the European Council, acting unanimously, to switch certain policy areas, from needing unanimity voting among member states to qualified majority voting, or they can switch from a special legislative procedure to the standard ordinary legislative procedure. It basically lets the EU speed up integration in specific areas without needing a full treaty amendment and those 27 national ratifications.
Precisely. You can think of it as an integration shortcut designed for flexibility. However, even this shortcut, designed to make things smoother, it comes with this massive political footnote. National parliaments get a say. They're given a veto power, essentially.
A veto. How does that work?
Well, if the European Council proposes using a Passerelle Clause, it has to notify all the national parliaments. And if just one single national parliament objects, gives a negative opinion within 6 months, then that Passerelle proposal is dead in the water. It cannot be adopted.
Wow. So a single no from just one national parliament can stop a decision that all 27 heads of state or government in the European Council have unanimously agreed on.
Exactly. Which does raise a rather important question, doesn't it? We started by talking about the treaties as this single, unified constitutional charter. implying this deep, almost federal-like legal structure. Yet the fact that a final veto power is held by just one national parliament within a mechanism like the Passerelle Clause, which is specifically designed for smooth, flexible integration, well, it really shows that deep, ongoing tension.
Yeah.
The tension between national sovereignty and the central EU structure.
So the provocative thought for you to take away and maybe explore on your own is this. How does the ever-present threat of a single national parliamentary veto, embedded within an integration mechanism designed for speed and flexibility, fundamentally shape or perhaps constrain the strategic direction and the actual pace of EU policymaking? Something to mull over. Thank you so much for joining us on this deep dive into the hierarchy of EU law. We really hope this clear map helps you navigate your studies and, of course, ace those exams.